On the phone line with us right now is Susan Jane Brown. Susan Jane is an attorney with the Western Environmental Law Center. That's westernlaw.org is the website. Previously, she was the National Resource Defense Counsel lawyer for Congressman Peter DeFazio in the 4th District of Oregon, a great guy in Washington, D.C. Susan Jane, welcome to the program.
Thank you very much. I appreciate it, Tom.
You and Western Law are at the forefront of trying to fight the efforts of the Trump administration to basically gut our forests. And now this thing with the Tongass National Forest up in Alaska, where my wife and I were just up there a few weeks ago, and it's just breathtakingly beautiful. I mean, wild eagles and bears, and well, it's all wild. It's just amazing. And
it's an amazing place.
Yeah, I've been to Alaska a few times, but it was always Anchorage. But this time we actually went through all these places, and it was just breathtaking. Let's start with the National Environmental Policy Act, NEPA. I understand that this is central to the Trump administration's efforts to gut these protections. Can you tell me about this?
Sure. So the Trump administration, as I'm sure you know, has definitely taken aim at the environment for the past 3 years, and now has finally turned its sights on the National Forest System and the Forest Service. Earlier this year, the Forest Service proposed to revise its National Environmental Policy Act regulations, or NEPA, and those regulations do a couple of things. First of all, NEPA is a look-before-you-leap law, so it requires federal agencies to take a hard look at the environmental consequences of its actions prior to moving forward with that particular action. And then it also allows for the public to have a voice in that decision-making. So what the Trump administration is doing with these proposed regulations is proposing to shift about 93% of its proposed decision-making to a very limited type of environmental review called a categorical exclusion. And in addition to doing that, it's also proposing to exempt categorical exclusions from public comment. So really this is an effort to shift environmental decision-making, environmental analysis under the radar and not allow the public a role in public lands management, which is extremely problematic from our point of view.
To what extent is the Trump administration, is what they're proposing to do here, an actual violation of law, or is it just a twisting of law? Are they ignoring law? Is a legislative remedy necessary? I mean, how does this play out?
Yeah, well, I think a little bit of all of the above is going on. The agency's proposed intention with these regulations is to increase efficiency when it makes decisions involving land management. And I think that we can all agree that we want a government that is efficient and that makes decisions in a prompt manner. So there's really nothing to complain about there. What's problematic with the Forest Service's approach is that it's attempting to solve the wrong problem here. There have been a number of studies not only conducted by other government agencies, but also by academics and, in fact, the Forest Service itself, to look at why it takes the agency as long as it does to reach particular decisions, which can range anywhere from 2 to 3 years to much longer if the project is very complex and involves a lot of natural resource issues. And what that research has identified is that there are other problems that lead to these long decision times, things like a lack of congressional funding or a lack of training of agency employees in the NEPA process. Other things like turnover. So, for example, with the Forest Service, their agency culture is one in which if you want to move up in the agency, you have to move around to different offices. So maybe you're stationed in Oregon, and then you go to Alaska, and then you're in Utah, and then you're in Florida. And so that moving around really means that it's musical chairs. And when you don't have someone in a decision-making capacity for a period of time, it's not surprising that they can't get their program of work accomplished. So it's these sort of unsexy internal agency cultural problems that are really at the root cause of the delay in decision making, not the fact that environmental analysis is required or that consulting with the public is required. It's really more about the agency and its internal culture than the National Environmental Policy Act.
Now,
so really this regulation is attempting to solve the wrong problem.
Right. I have heard that the governor of Alaska met Trump's plane when he was returning from Asia recently, and Air Force One, while they were stopping in Anchorage to refuel, and got on the plane and had a conversation with Trump, basically lobbying him for this because it's jobs in Alaska, and you can understand that, from a purely political point of view, but that would suggest that this decision has been made based on politics rather than the law. Does NEPA have the ability to deal with that kind of pressure?
Well, it's a good question. And what you were talking about there was Trump's request or demand, I guess, to Agriculture Secretary Perdue to grant Alaska an exemption to the roadless rule, which
right.
is a national rule that was actually enacted in the Clinton era. And Alaska has never liked that Clinton rule. It has always believed that Alaska is different, and Alaska is different, but it's not so different that we shouldn't also protect the roadless areas in Alaska as well. And so what Trump is now saying he's going to do is to mandate that Alaska receive an exemption to the roadless rule. And I think what we've learned so far from this administration is that the president likes to do a lot of things ad hoc that are patently illegal. And I would suggest that any edict to grant Alaska an exemption would be illegal, not only under the National Environmental Policy Act, but also the Administrative Procedure Act, which requires federal agencies to follow a very rigorous process when it makes a rulemaking decision. So Trump is clearly trying to do an in-run around the law in order to deliver a gift to Alaska.
Remarkable. Olivia Glasscock, who is an attorney at Earth Justice, said, and I quote, "The Trump administration is rushing to hand favors to big oil, gas, logging, and mining interests once again with the Forest Service's latest proposal to attack bedrock environmental law." To what extent is this all one thing? I mean, we've got these giant fossil fuel companies that have been funding climate change denial for years and years, ExxonMobil and others. The fossil fuel billionaires, the Koch brothers, funding, not just climate change denialism, but also this whole libertarian movement that there literally should not be public lands in the United States, that everything should be privatized. To what extent is this all one fabric that needs to be taken on in a more systemic fashion? Or are they coming after us in a systemic fashion and we're trying to deal with them piecemeal, and that's part of the problem? Or is my analysis of the situation completely wrong?
Well, I think you're right on both alternatives there, actually. Certainly this administration has made no bones about its desire to have energy dominance here in this country, and that has led to a number of rollbacks of clean air and clean water regulations that were put in place to protect our public lands and communities. I look at this most recent round of rulemaking, both with the Forest Service's NEPA rule and also the Tongass, as just part and parcel of that. It is definitely an attempt to open public lands to private development and to cut the public out of the process. And we've seen that time and again from this administration. So I'm not entirely surprised. It's disturbing, but it does seem to be the way that this president conducts himself. And the courts have responded. And I think that's the important thing to keep in mind here, is that although it's been rocky, it is true that the system of checks and balances is working, and that the federal court system has held the administration's feet to the fire and has said, no, you can't just simply waive environmental laws or run roughshod over administrative procedures. You actually have to follow the law. And so as a lawyer, that's comforting to see, even though we do have to go to court very regularly in order to enforce those rights.
Are you concerned about all these right-wing judges that in some cases people have never even been in a courtroom, never tried a case, nothing, that Mitch McConnell is shoving through,
Yes,
eroding that bulwark?
For sure. I'm definitely concerned about what I'm seeing. I live here in Oregon, and we're within the jurisdiction of the Ninth Circuit Court of Appeals, which has always been sort of the favored punching bag of the right. They believe that the court is very liberal and issues all these liberal decisions, when in fact that's really not the case. It is the case that the Ninth Circuit has a very large jurisdiction. It covers a lot of the West, including most of our western public lands. So there are a lot of decisions that come out of the Ninth Circuit that touch on public land issues that overturn federal agency decisions. And I think that the bottom line point there is that those decisions were illegal. Not that the court is putting a thumb on the scale, but rather has evaluated what the law says and what the agency did and makes a ruling whether or not that action was legal.